Hello and welcome to this special short session, which is entitled The Anatomy of a Criminal Case. Now, the purpose of this session is really to understand the stages of a criminal case. Now, the popular picture is of the barrister acting as an advocate in the courtroom. However, counsel's role is necessarily much wider than that. And so the point of today's presentation is for us to understand the relevant stages in a case, and this would hopefully help to build a much larger picture and contribute to our understanding of the advocate's particular role, which leads us nicely to the first part, which is the role of the defense barrister. A barrister only represents a defendant if briefed to do so by a solicitor. Solicitors themselves have complete rights of audience in the magistrate's court, and so there is nothing a barrister can do there that a solicitor cannot. If a barrister is instructed, the brief, generally entitled Instructions to Counsel, usually consists of a short introduction to the case written by the instructed solicitor, together with a proof of evidence, that is, the written statement from the defendant. At the early stages of the case, the brief sent to the barrister may consist of very little. Indeed, there will be cases where the barrister is the first lawyer the defendant sees in connection with this particular offense. In that case, the brief may consist of only a backsheet, that is, a sheet of paper containing the name of the defendant, the court that the defendant is appearing, and the name and address of the solicitors. When the barrister meets the client, it is necessary to go through the proof of evidence, assuming there is one, with the client. It may be that there are things the client wishes to correct or to add. Where the barrister is taking instructions from the client at court shortly before the hearing, there may only be a short time available, and counsel should give priority to eliciting information which is relevant to the hearing which is about to take place. For example, if the reason for the appearance is to make a bail application, then the information which counsel needs to draw out first from the client should relate to matters which are relevant to bail. Other matters can be dealt with after the more important information has been discovered. By the time the case is ready for trial, counsel should have a much fuller brief which contains not only a proof of evidence from the client, but also statements from any witnesses whom counsel is to call in support of the defense case. In the case of Crown Court trials, defense counsel will also be in possession of the written statements made by the witnesses whom the prosecution intend to call, as the sending of these statements to the defense is an integral part of the process whereby the case is transferred to the Crown Court. In the case of magistrates' court trials, counsel for the defense should have copies of the witness statements made by the prosecution witnesses. If defense counsel has not received copies of the prosecution witness statements in a magistrate's court case, the CPS should be asked to supply them. If the solicitor has not already done so, defense counsel should make sure that the defendant looks through the statements made by the prosecution witnesses and so has a chance to comment on those statements. This may give counsel very useful material upon which to base the cross-examination of those witnesses when the time comes. In the magistrate's court, where counsel has been instructed on behalf of the defendant, no representative from the solicitor's office will be present. Normally, the brief sent to the barrister will include copies of statements taken by the instructing solicitor. From each intended defense witness, such statements are important since the advocate needs to know what the witness is expected to say. If the defendant brings witnesses who have not made statements to the instructing solicitor, counsel will have to take statements from those witnesses. In the Crown Court, a representative from the instructing solicitor should usually be present, although this will usually be an outdoor clerk, that is, a representative who is not legally qualified. Let's turn now to legal aid. Publicly funded representation for defendants is available, but legal aid will be granted only if it is in the interest of justice to do so, as per Section 17 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012. In deciding whether this requirement is met, the following factors are taken into account. Whether the defendant would, if convicted, be likely to lose their liberty or livelihood or suffer serious damage to their reputation. Whether the determination of any matter arising in the proceedings may involve consideration of a substantial question of law. Whether the defendant may be unable to understand the proceedings or to state their own case. Whether the proceedings may involve the tracing, interviewing, or expert cross-examination of witnesses on behalf of the defendant, and whether it is in the interest of another person that the defendant be represented. As well as satisfying the merits test, the defendant must also satisfy a means test. Where the defendant is in receipt of certain state benefits, the means test is satisfied automatically. In the remaining cases, account is taken of the defendant's income. Let's turn now to the Crown Prosecution Service. In all but minor cases, the CPS will be involved in the decision whether or not to charge a suspect. In more serious cases, where the police will oppose the grant of bail, the police will charge the suspect, but only after having received advice from a Crown prosecutor on whether there is sufficient evidence to charge the suspect, and if so, with what offences. In other cases, the suspect will be released on bail, pending a decision by the CPS whether or not to proceed with the case. And if the decision is in favor of proceeding with one or more charges, the CPS will issue a written charge and requisition requiring the suspect to appear before a magistrate's court, or else the defendant will return to the police station to be charged there. In the magistrate's court, the CPS is represented by a Crown prosecutor or by an agent, that is, by a solicitor or barrister instructed by the CPS. In the Crown Court, the CPS will usually be represented by a barrister, although increasing numbers of Crown prosecutors are now conducting Crown Court trials. In the Magistrates' Court, the CPS file takes the place of the brief for the prosecutor. In the Crown Court, prosecuting counsel receives a brief which is very similar in form to the brief sent to counsel for the defense. The file or brief, as the case may be, will contain an introduction written by a Crown prosecutor, copies of written statements made by the witnesses to be called on behalf of the prosecution, and details of the defendant's previous convictions, if any. In the Crown Court, a representative from the CPS should be available to assist counsel, and the police officer in charge of the case will also be present. In the magistrate's court, the prosecutor will be alone, although the police officer in charge of the case will be present for the trial, but not for any preliminary hearings which precede the trial. Now, let's turn to the stages of a criminal case. Now, this is an overview. Now, where proceedings were commenced by the issue of a written charge and a requisition requiring the suspect to attend court, the procedure established under Section 29 of the Criminal Justice Act 2003, counsel is likely to attend only for the trial itself. This is because the question of bail does not arise, and so remand hearings where the question of bail is addressed do not take place. The other method of commencing proceedings is to arrest and charge the suspect. Under Section 24 of the Police and Criminal Evidence Act 1984, in other words known as PACE 1984, a police officer may arrest the suspect for any offense subject to a test of necessity. For example, to allow the prompt and effective investigation of the offense, or to prevent any prosecution for the offense being hindered by the disappearance of the suspect. The suspect who was being arrested will usually be interviewed at the police station. At the police station, the suspect is entitled to legal advice. That advice will invariably be provided by a solicitor, not by a barrister. If the suspect is to be charged with an offense, either that will happen at the police station, the police haven't first sought advice from a Crown prosecutor, or the papers will be sent to the CPS, who will decide whether to charge the suspect, and if so, with what offense, in which case the CPS will commence proceedings through the issue of a written charge and requisition, or else, if the suspect was released on police bail, the charging may take place when they return to the police station, as required by the terms on which bail was granted. A suspect who has been charged at the police station may either be granted bail by the police or else be held in custody until the next sitting of the magistrate's court, when the magistrates can be asked to grant bail to the defendant. If police bail is granted, counsel may attend remand hearings, but assuming the prosecution do not subsequently oppose bail, the grant of bail is a formality, and so there is little for counsel to do. Where the CPS are deciding whether a suspect ought to be charged, regard must be had to the strength of the evidence against the suspect and to whether it is in the public interest to continue the prosecution. In complex cases, the CPS may seek the advice of counsel. If proceedings were commenced by the arrest and charge of the suspect and police bail was withheld, counsel may be instructed to attend the magistrate's court to make an application for bail on behalf of the defendant. In many cases, however, the first bail application will be made by a solicitor. Where the prosecution wish to oppose the grant of bail application will be resisted by the CPS representative. If that application for bail is unsuccessful, counsel may be briefed to return to the magistrate's court a week later to make a further bail application. If bail is withheld by the magistrate after the second application for bail, counsel may be asked to return to the magistrate's court to reapply for bail if there is a material change in circumstances which enables a further bail application to be made. Alternatively, where bail has been refused by a magistrate's court, the defendant may apply for bail in the Crown Court. In the Crown Court, bail will be opposed by an advocate instructed by the CBS or by a Crown prosecutor. In addition to the remand hearings in the magistrate's court, if the offence is triable either way, that is, it can be tried either in the Crown Court or in a magistrate's court, counsel may be instructed to attend the magistrate's court to represent the defendant at the plea before venue and allocation, that is, mode of trial hearing, where the defendant is asked to indicate whether he intends to plead guilty or not guilty. If the defendant gives no indication or indicates an intention to plead not guilty, the next step is for the decision to be taken whether the case should be heard in the magistrate's court or in the Crown Court. A defendant who indicates a guilty plea is deemed to have entered a guilty plea, and so the court will either pass sentence or commit the defendant to the Crown Court, which has greater sentencing powers. Again, the prosecution will be represented by a Crown prosecutor or by an advocate instructed by the CPS. In some cases, prosecuting counsel may be asked to advise on evidence and/or on the question of disclosure to the defense of material which the prosecution have, but which they do not intend to use at the trial. Defense counsel may be instructed to advise, for example, on the contents of, or even to draft the statement of the defense case, which, in the case of Crown Court trials, must be served on the prosecution. Next, counsel may be instructed to appear for the trial itself. This trial will be in the magistrate's court if the offence is a summary one, that is, triable only in a magistrate's court, or if the offence is a triable either way one, again, that's triable in magistrate's court or in the Crown Court, and both the defendant and the magistrates agreed at the allocation or the mode of trial hearing to summary trial. If the offence is triable only on indictment, or the offence is triable either way, and the allocation or mode of trial hearing resulted in a decision in favor of trial on indictment, the trial will take place in the Crown Court. In the magistrate's court, the prosecution will be conducted by a Crown prosecutor or by an advocate instructed by the CPS in the Crown Court. The prosecution will usually, but not invariably, be represented by counsel. Wherever the case is heard, if the defendant either pleads guilty or is found guilty, defense counsel will have to make a plea mitigation before sentence is passed. At the conclusion of the case, it may be necessary for defense counsel to advise the defendant on the possibility of appeal against conviction and/or sentence. Where the trial took place in the magistrate's court, that appeal would normally be heard in the Crown Court, although an appeal on a point of law may be made to the High Court, either by way of the case stated or by means of an application for judicial review. Where the trial took place in the Crown Court, appeals are heard by the Court of Appeal Criminal Division. I think now it's worth reviewing these stages in a little bit more detail. And we begin now with the bail application. In most cases, on the first occasion that a defendant appears before the magistrate's court charged with a particular offense, representation will be provided either by a duty solicitor or by a solicitor from the firm which later instructs counsel. An application for public funding may be made at the time of that hearing. There will be occasions, however, where the barrister is the first lawyer the defendant meets in connection with this offence. It may be, for example, that the defendant agreed to be interviewed by the police without a lawyer being present, and after being charged with an offence and finding that police bail was withheld, contacted the firm solicitors they've used before. If there is insufficient time for a solicitor from that firm to see the defendant prior to the first court appearance, counsel may receive instructions by telephone, email, or fax to go to the magistrate's court. In that case, it will be for counsel to take instructions from the defendant to give preliminary advice and to make a bail application. In other cases, counsel may be making a bail application following an earlier unsuccessful bail application made by the solicitor or, in fact, by another barrister. Where bail is withheld, the accused is remanded in custody and will be held in prison until the next court appearance. The role of defense counsel when attending court to make a bail application involves a number of elements, which includes preparation, advice, and advocacy. In particular, counsel will have to take instructions from the client. Now, if a proof of evidence from the defendant is included in the brief, it is important to check with the client that it is complete, accurate, and up to date. If there is no proof of evidence, it is up to counsel to elicit all the necessary information from the defendant. In deciding what questions to ask the defendant, counsel should consider the factors set out in the Bail Act 1976, for example, risk of absconding, committing offences while on bail, or interfering with witnesses, all of which are assessed in the light of such matters as the nature and seriousness of the present offence, the defendant's previous convictions, if any, the defendant's community ties, and their record of answering bail in the past. The next thing they do is they advise the client. Now, if this is the client's first court appearance, they may need reassurance. It may therefore be necessary to explain to the client what will happen in court. It is highly likely that the client will ask counsel to advise on the probable result of the bail application. Furthermore, the client may seek advice about other aspects of the case. Where such advice is given, a short note of the advice should be endorsed on the brief, signed and dated by counsel, so that the solicitor knows what counsel has said to the client. Next is that they address the court in favor of bail. Assuming the prosecution oppose the grant of bail, the prosecutor addresses the court first and explains to the court the grounds upon which the prosecution say that bail should be withheld. Counsel for the defense then replies to these submissions and will try to show either that the prosecution objections to the grant of bail have no foundation, or that those objections can be overcome by the imposition of conditions on the grant of bail. No witnesses are called unless a surety comes forward, in which case that person will usually have to give evidence showing their suitability to act as surety. The submissions to the court should be based on the matters that the court is required to consider under the Bail Act 1976. Next is that the counsel advises the client on challenging refusal of bail. If bail is withheld, counsel should advise the defendant and later communicate this advice to the instructing solicitor on any steps which might be taken to increase the chance of bail being granted, for example, the provision of a surety, and or whether an application for bail should be made to the Crown Court. The role of the prosecutor is rather more limited, simply making representations opposing the grant of bail. In doing this, the prosecutor will usually have to rely on notes contained in the CPS file. Those notes are based on information supplied by the police. The police officer in charge of the case is unlikely to be present at the bail application. There may occasionally be some scope for negotiation between defense counsel and the prosecutor. It might be, for example, that the prosecutor will agree not to oppose the grant of bail if the defendant agrees that the grant of bail should be subject to certain conditions. If the first bail application is unsuccessful, the defense may make a second application to the magistrates a week later. This is so even if the second application says nothing different from the first application, although the advocate making the application will normally try to find something different to say. Once the magistrates have heard two fully argued bail applications, however, they can only hear a further application if there's a material change in circumstances. That is, the defense can put forward an argument which has not been put forward already. Where bail has been refused by the magistrates following a fully argued bail application, it may be appropriate to make a further bail application in the Crown Court. The procedure in the Crown Court is very similar to that in the Magistrates' Court. That is, the prosecutor set out the reason for opposing the grant of bail, and defense counsel then replies to those submissions. However, the defendant will not usually be present in the court, and the CPS will usually, but not always, be represented by counsel. If the offence is triable in the Crown Court, the case may be sent to the Crown Court for trial after the first appearance in the Magistrates' Court. If the magistrate refuses bail, any further application for bail will therefore have to be made in the Crown Court. We're still here at the stages of criminal case. We are considering the allocation or mode of trial hearing. Okay. Now, where the defendant is accused of an offence which is triable either way, that is triable in either a magistrate's court or the Crown Court, counsel may be asked to advise the client on which court should try the case. This advice will almost always be given orally and will generally be given just before the hearing in which mode of trial is determined. At this stage, if not before, the client may well need advice on plea, since determination of mode of trial begins with a plea before venue hearing, at which the defendant is asked to indicate whether he or she intends to plead guilty or not guilty. If the defendant indicates an intention to plead guilty, this is regarded as a guilty plea. At that point, the magistrates will either proceed to the sentencing stage, if necessary, after an adjournment for a pre-sentence report to be prepared by a probation officer, or else commit the defendant to the Crown Court for sentence. Now, the Crown Court having greater sentencing powers than the Magistrates' Court, of course. If, on the other hand, the defendant either indicates an intention to plead not guilty or gives no indication as to the intent to plea, the magistrates will proceed to determine the question of mode of trial. At this stage of the hearing, the magistrates have firstly to decide whether the case is suitable for summary trial. The key question is whether, in the event of the defendant being convicted, the sentencing powers would be adequate to deal with the case. If the magistrates decide that the case is not suitable for summary trial, the case has to be sent to the Crown Court for trial. If the magistrates decide that the case is suitable for summary trial, that is, that they accept jurisdiction, the defendant is asked where he or she wishes to be tried. This is because in the case of an offence which is triable either way, the defendant has the right to choose to be tried on indictment, that is, at the Crown Court. When mode of trial is being determined, the prosecution and defense both have the right to make representations regarding the appropriate mode of trial. If the defendant wishes to elect trial on indictment, there is little point in the defense making any representations because the defendant's right to choose Crown Court, because of the defendant's right to choose Crown Court trial. If, on the other hand, the defendant wants to be tried in the magistrate's court, but the prosecution are seeking trial in the Crown Court, counsel for the defendant will first have to try to persuade the magistrates that the case is suitable for summary trial. In advising the client on whether or not to elect Crown Court trial in the case of an either way offence, counsel will need to be aware of the various arguments for and against the two types of trial. Jurors tend to be less case hardened than magistrates, which may explain why the acquittal rate is slightly higher in the Crown Court than in the Magistrates' Court, where it is likely that the defense will seek to have some of the prosecution evidence, such as a confession, ruled inadmissible. Crown Court trial is preferable because matters of admissibility are dealt with by the judge in the absence of the jury. Now, this separation of functions is not possible in the Magistrates' Court, where the justices are triers of both law and fact, although it should be borne in mind that under the Courts Act 2003, it is possible to ask a bench of magistrates to make a pretrial ruling to decide any question as to admissibility of evidence or any other question of law relating to the case. This pretrial ruling is binding on the trial court, and so if evidence is ruled inadmissible in a pretrial ruling, that evidence is inadmissible at the trial, and the magistrates who tried the case will hear nothing about that evidence. Another factor relevant to the choice between Magistrates' Court and Crown Court trial is that trial in the Magistrates' Court is a little less formal, and so maybe a little less daunting for the accused than jury trial. Trials in the Magistrates' Court also tend to be considerably shorter than trials in the Crown Court. Those trials also tend to be cheaper, which may be an important consideration to the accused, where the defense is not publicly funded. The cap on the sentencing powers of the magistrates cannot be said to be an advantage of summary trial, as it is effectively negated by the power of the magistrate's court to commit the defendant to the Crown Court for sentence. Now let's think about how we would advise the prosecution. Counsel who has been briefed to prosecute in a forthcoming Crown Court trial may be asked by the CPS to advise on the evidence and sometimes to draft or redraft the indictment before the trial takes place. This involves examining the witness statements made by the prosecution witnesses in order to see how strong the prosecution case is. Counsel has to consider if the case can be proved, for example, advising that the police take further statements from existing witnesses to fill gaps or clarify ambiguities, or advising that further investigations be made. The advice must be both realistic and practicable. It must be remembered that the police do not have limitless resources. Where the trial is to take place in a magistrate's court, these matters will almost invariably be considered by a Crown prosecutor, not by a barrister in private practice. Now let's think about advising the defendant. Counsel for the defense may be asked to advise on evidence prior to a Crown Court trial. This advice will often be given orally during a conference with the client, rather than in writing. Such conferences usually takes place in counsel's chambers or in an interview room in a prison if the defendant has been remanded in custody. Again, any advice must be realistic and practicable. It must also be borne in mind that where the defendant is legally aided, further inquiries involving considerable expense are unlikely to be covered by public funds. Prior to a magistrate's court trial, it is very rare for defense counsel to have a conference in chambers or to give written advice. The conference usually takes place in the court building shortly before the trial is due to begin. The function of the pretrial conference, whether held sometime before the date fixed for trial or just before the trial is due to start, may include some or all of the following elements. A, taking instructions from the client, that is, gathering information. By the time of the trial, counsel will be in possession of a proof of evidence from the defendant, which sets out the client's version of events. However, it's still useful to get clients to go through their version of events. The solicitor may have missed something, or the defendant may remember something new. Whilst it is unethical and therefore strictly forbidden for counsel to coach the defendant, that is, to suggest evidence which the defendant might give, there is no objection to counsel questioning the client closely on the evidence he or she will be given. It is helpful for defendants to go through the evidence they will be given in court in order to prepare for cross-examination by the prosecution. Where counsel is in possession of the witness statements made by the prosecution witnesses, the defendant should also be asked to comment on what those witnesses say so that counsel can decide what questions to ask them by way of cross-examination. It may be that the solicitor has already performed this task so that the defendant's proof of evidence contains comments on the prosecution evidence. Even then, it can be helpful to ask the defendant if there is anything he or she wishes to add to those comments. B, advising the defendant on plea and tactics. Where the client has not received full advice on plea from the solicitor or from counsel on a previous occasion, it may be necessary for counsel to advise the defendant based on what the client has said about their version of events on plea. It may be, for example, that the defendant has indicated an intention to plead guilty, but then says something which amounts to a defense. That is, a person accused of theft says they did not realize that the property belonged to someone else, for example. Whilst counsel ought to advise on the advantages of pleading guilty, such as a reduction in sentence, the client should be left in no doubt that they should only plead guilty if they are guilty. Where the defendant is going to plead not guilty, it may also be necessary to advise on tactics. For example, what lines of cross-examination to pursue and what evidence to call. C, taking instructions on matters relevant to sentence. Counsel should be careful to have all the information needed to make a plea in mitigation. Instructions should therefore be taken on matters which should be relevant to sentence. This is so even if the client is going to plead not guilty, since in the event of the defendant being convicted, there may be no time for a further conference between the defendant being convicted and the moment counsel has to start making the plea in mitigation. And D, advising on sentence. Whether the defendant is going to plead guilty or not guilty, it will almost always be necessary to give advice on the sentence, which is likely to be imposed in the event of conviction. Counsel will therefore have to be familiar with the relevant guidelines, which are, of course, issued by the sentencing counsel. Counsel representing a defendant at an early stage of the proceedings may be asked to give advice about later stages of the case. On occasions, for example, counsel may be instructed to attend the magistrate's court to make a bail application or for the mode of trial hearing, and may be asked for advice then by the defendant. Provided counsel is sufficiently well acquainted with the background to the case, there is no objection to such advice being given, although a short note setting out the advice given should be endorsed on the brief so that the instructing solicitor and any barrister involved in the case at a later stage will know what was said. However, where the advice is given without full knowledge of the prosecution case and defense response to that case, it should be made clear to the client that the advice is only provisional and may change if new information comes to light. Pre-trial disclosure. A particularly important aspect of advising on evidence concerns the rules which govern pre-trial disclosure. The rules which apply to the prosecution are different from the rules which apply to the defense. The disclosure rules are contained in the Criminal Procedure and Investigations Act 1996, the CPIA 1996. As regards disclosure by the prosecution, a distinction has to be drawn between material that the prosecution will be using as part of their case and material which they will not be using. Pre-trial disclosure by the prosecution. By the day of the first hearing, the prosecutor must have provided initial details of the prosecution case to the defense. If the defendant is in custody, these details must include a summary of the circumstances of the offense. If the defendant is not in custody, the details must also include any account by the defendant in interview and any written witness statements that the prosecutor has available and considers material to plea or to mode of trial or to sentence. If the case is to be tried in the Crown Court, copies of the statements made by witnesses whom the prosecution intend to call at the trial must be supplied to the defense if this has not already been done. The defense must also receive the prosecution witness statements prior to any trial in the magistrate's court. Where the prosecution wish to use a witness whose statement has not already been served on the defense, a notice of additional evidence, including a copy of the witness statement, must be served on the defense prior to the trial. The prosecution are also under a statutory duty to disclose certain material other than the statements of the persons they will be calling as witnesses. Under the CPIA 1996, the prosecutor must disclose to the accused any prosecution material which might reasonably be considered capable of undermining the case for the prosecution against the accused, or of assisting the case for the accused. This applies to all trials, whether in the Crown Court, the Magistrates' Court, or the Youth Court. It follows that by the time of the pre-trial conference at the latest, counsel for the accused should be aware both the case to be met and of any material that has come to the attention of the prosecution and which undermines the case or supports the defense case. Now, pre-trial disclosure by the defense. The Criminal Procedure and Investigations Act 1996 imposes a compulsory duty of disclosure on the defense, but this compulsory duty applies only to trials in the Crown Court. This disclosure takes the form of a defense statement. This has to A, set out the nature of the accused's defense, including any particular defenses on which the accused intends to rely. B, indicate the matters of fact on which the accused takes issues with the prosecution. C, set out in the case of each such matter why the accused takes issues with the prosecution. D, sets out particulars of the matters of fact on which the accused intends to rely for the purposes of their defense. And E, indicate any point of law, including any point as to the admissibility of evidence or abuse process which the accused wishes to take, and any authority on which they intend to rely for that purpose. Where the accused wishes to rely on an alibi, the defense statement must give full particulars of the alibi and of any witnesses the accused believes may be able to give evidence in support of the alibi. The defense also have to supply this prosecution with details of any witnesses they propose to call to support the defense case. In the case of summary, that is magistrates' court or youth court trials, the Act enables the defense to make voluntary disclosure of their case. Following service of the defense statement, the CPS have to review the unused material to see if there is anything which undermines the prosecution case or supports the defense case. If so, it should be disclosed to the defense. If the defense fail to comply with the compulsory duty of disclosure prior to Crown Court trial, or if the defense case at trial differs from that disclosed to the prosecution, whether the disclosure was compulsory or voluntary, then adverse inferences can be drawn by the jury or magistrates as the case may be. It will normally be more appropriate for instructing solicitors to draft the defense statement, since counsel generally have had little involvement in the case at this stage. Nonetheless, there is no reason why a barrister should not draft a defense statement. However, counsel must ensure the defendant understands the importance of the accuracy and adequacy of the defense statement, has had the opportunity of carefully considering the statement drafted by counsel, and has proved it. Preliminary hearings in the Crown Court. The Criminal Procedure and Investigations Act 1996 requires preliminary hearings to take place before all Crown Court trials. The purpose of the preliminary hearing is to ensure that the issues in the case are defined before the start of the trial and reduce the number of cases where the defendant was due to be tried on a not guilty plea, but then pleads guilty at the start of the trial, giving rise to what is sometimes called a cracked trial. Plea and trial preparation hearing. In the case of Crown Court trials, other than those which are likely to be complex or lengthy, in which case a preparatory hearing will be held, a plea and trial preparation hearing, or PTPH, will take place. At this hearing, the defendant is asked to enter a plea. Assuming the defendant pleads not guilty, a date is fixed for the trial. Where the defendant pleads not guilty, prosecuting and defense counsel are expected to inform the court of matters such as the issues in the case, the number of witnesses to be called, any points of law likely to arise, including questions on the admissibility of evidence and whether any technical equipment such as video equipment is likely to be needed. It follows that it is very important that by the time of this hearing, the factual and legal issues in the case have been identified. At this hearing, the judge is empowered to make rulings on the admissibility of evidence and on any other questions of law which are relevant to the case. These rulings are binding for the whole of the trial unless there is an application for the ruling to be altered, but such an application can be made only if there has been a material change in circumstances since the ruling was made. Let's turn to the drama, the trial. Defense counsel and the prosecutor may attend court expecting a trial to take place. However, a trial will not take place if either defendant pleads guilty to the charges or charge, or the prosecution accepts a plea to a lesser offense. If in the Crown Court any negotiations with the prosecution regarding the acceptance of a plea of guilty to a less serious offense than that charge will usually take place at the PTPH, where the case is to be heard in the magistrate's court. Such negotiations will usually take place just before the trial. We have already seen that counsel for the defense may have to give advice to the defendant in the conference, which takes place immediately before the trial. During the trial itself, counsel is involved in three main ways: A, making speeches; B, examination in chief; and C, cross-examination. In relation to making speeches, at the start of the trial, the prosecution will make an opening speech. The purpose of this opening speech is to prepare the jury or magistrates for the evidence they are about to hear. The prosecution case is summarized so that the jury or magistrates can put the evidence they're about to hear in context. The prosecution and the defense, in most cases, each make a closing speech. The purpose of closing speech is to highlight the strength of one's case and, where possible, to minimize the impact of any weaknesses. The defense, for example, will stress any doubt in the prosecution case and any explanation which the defendant has given for apparently incriminating evidence. As well as these opening and closing speeches, it may be necessary for counsel to address the court on the admissibility of certain evidence, or to make, or if prosecuted, to respond to a submission that there is no case to answer. A submission of no case to answer may be made by the defense at the end of the prosecution case. The essence of this submission is that the evidence adduced by the prosecution is so weak that no reasonable tribunal, jury, or bench of that, or bench of magistrates, as the case may be, could convict the defendant on the basis of that evidence. The prosecutor is entitled to respond to this submission. If the court accepts that there is no case to answer, the defendant is acquitted. If the court finds that there is a case to answer, well, the case continues. The next stage being for the defense to adduce their evidence. B. Examination in chief. This means getting the witness to tell the story, answering questions such as who, when, where, describe. Care must be taken not to lead the witness on matters that are in dispute. A leading question is one which contains or suggests the answer. A question which can be answered with a simple yes or no will usually be a lead-in question. Before going into court, counsel must have decided what he or she hopes to achieve with the particular witness. Since examination in chief should only bring out evidence which is relevant to the case, counsel will always be in possession of a written statement from the witness, which obviously forms the basis of the questions which will be put to the witness. Counsel should be alert to any inadmissible evidence that may be contained in the witness's written statement, for example, hearsay or references to previous dealings between the defendant and the police, unless such evidence has been ruled admissible, so that those areas can be avoided in questioning. Examination in chief can also be used to anticipate questions which might be put to that witness in cross-examination. For instance, in a case involving identification evidence, prosecution counsel would, in examination in chief, ask witness who claims to have identified the witness who claims to have identified the defendant as a perpetrator about the circumstances of that identification. For example, the distance, light-in, obstructions to view, etc. The answers to these questions might well make it more difficult for counsel for defense to cross-examine effectively on the matters. The defendant has been present in court throughout the trial, and so has heard the evidence of the prosecution witnesses. The defendant might be asked in examination in chief to comment on what he has heard. For example, you've heard Miss Jones say blah blah blah. What do you say about that? C. Cross-examination. Now this means probing the story told by the witness. In the Crown Court, counsel for the defense will be in possession of the written statements made by the prosecution witnesses. In the Magistrates Court, counsel for the defense will usually have the prosecution witness statements. However, the prosecution never have the written statements made by witnesses for the defense. Obviously, it's easier to prepare cross-examination if one has advance notice of what the witness is going to say. Cross-examination essentially focuses on inconsistencies and on the probing of weaknesses. Inconsistencies between what the witness is saying now and what they have said in their written statement. Inconsistencies in the evidence which the witness has given to the court, for example, in the course of the witness testimony, the color of the getaway car changes from dark blue to black. Inconsistencies between what the witness has said and what another witness says. Inconsistencies between what this witness is saying and the theory which counsel has formed about the case. Inconsistencies between what the witness is saying and what common sense suggests actually happened. For example, witness who says the car was traveling at 70 miles per hour and that it braked sharply and stopped within a distance of 15 meters cannot be correct. And weaknesses, of course, in the other side's evidence, for example, establishing that the witness was some distance from the scene of the crime and that there were obstructions to the observation. Is there a basis for suggesting that the witness is mistaken? Does the witness have a motive for misleading the court? It is important that in cross-examination you put your case. In other words, if a witness called by your opponent might be able to comment on part of your case, that witness should be given the chance to do so. In the case of counsel for the defense, this will include putting to the witness those parts of witness evidence which differ from or are inconsistent with the defendant's account of what happened. Many practitioners have in mind their closing speech from the moment they start to prepare the case. In thinking about your closing speech, you are asking yourself how you are going to persuade the jury or magistrates to come to the conclusion that you want to come to. In other words, how will you persuade them to accept your theory of the case? This will determine what evidence you put before the court through the examination in chief of the witnesses and what questions you ask in cross-examination of your opponent's witnesses. Much of the case analysis process involves consideration of strengths and weaknesses, the strengths and weaknesses of your case, strengths and weaknesses of your opponent's case. Your task is to think about ways of emphasizing or maximizing the strengths of your case and ways of improving or minimizing the effect of the weaknesses of your case. Also, it is to see if you can reduce the effect of the strengths and increase the impact of the weaknesses of your opponent's case. That process is basically expressed in a series of questions. In relation to strengths of your case, ask yourself, what evidence supports your case? How might your opponent try to undermine the evidence that supports your case? How might you be able to prevent your opponent from undermining the evidence that supports your case? Weaknesses of your case. You might wish to ask, what evidence weakens your case? How might you reduce the impact of the evidence that weakens your case? How might your opponent be trying to prevent you from undermining the evidence that weakens your case? In relation to strengths of your opponent's case, ask yourself, what evidence supports your opponent's case? How might you try to undermine the evidence that supports your opponent's case? And how might your opponent try to prevent you from undermining the evidence that supports their case? And also, in relation to the weaknesses of your opponent's case, ask again, what evidence weakens your opponent's case? How might you increase the impact of the evidence that weakens your opponent's case? And how might your opponent try to prevent you from increasing the impact of the evidence that weakens their case? We turn now to plea in mitigation. Plea in mitigation is required if the defendant pleads guilty or is found guilty. Sentence is usually passed either immediately or after an adjournment for the preparation of a pre-sentence report by the court which convicted the defendant. However, if the defendant is convicted in the magistrate's courts of an offence which is triable either way, the magistrates may, if they decide that their sentencing powers are insufficient to deal with the case, commit the defendant to the Crown Court to be sentenced, the Crown Court having greater sentencing powers. In that case, a plea in mitigation will have to be delivered in the Crown Court. It should be borne in mind that where sentence is being passed in a magistrate's court following an adjournment, the magistrates who pass sentence will probably not be the same ones who convicted the defendant. If sentence is passed immediately after the defendant has been convicted following trial, that is, the defendant pleaded not guilty but was convicted, the prosecutor will usually simply tell the court about any previous convictions recorded against the defendant. If the defendant pleads guilty or is being sentenced at a hearing which takes place after the trial at which the defendant was convicted, the prosecutor will also have to explain to the court precisely what the defendant did. The next step is for the defense counsel to make a plea in mitigation on behalf of the defendant. The essence of a plea in mitigation is to draw the court's attention to any mitigating factors related to the offense itself and to emphasize any personal mitigating circumstances related to the offender. The plea in mitigation will be based on information gathered from the client and the proof of evidence and the things said by the client prior to the hearing. And in many cases, on information contained in a pre-sentence report prepared by a probation officer. A list of the client's previous convictions, if any, should be in the brief. If not, the list can be obtained from the prosecutor. Counsel should check that the defendant agrees that the list of previous convictions is correct and should seek information from the client about the circumstances of those convictions, since they may be relevant to the sentence to be passed in the present case, and that the defendant is content with the comments made by the probation officer in the pre-sentence report. Counsel should be prepared to probe the client for full details of mitigating factors related to the offense itself or to the client's personal circumstances. Before advising the client on likely sentence or presenting a plea in mitigation, counsel must be familiar with the approach taken by the court to sentencing for the particular offences of which the defendant has been convicted. For example, if the starting point is a custodial sentence, counsel should indicate awareness of this before trying to persuade the court to impose a lesser sentence. And of course, you can refer to the sentencing counsel's various guidelines on this point. Let's turn now to appeals, which is the final part of our understanding of the various stages of criminal case. Appeals from the magistrate's court. Most appeal against conviction and or sentence from the magistrate's courts are heard by the Crown Court. An appeal against conviction takes the form of a complete rehearing of the case. The prosecution will be represented by counsel instructed by the CPS or by a Crown prosecutor. Counsel for the defense may or may not have represented the defendant in the magistrate's court. Permission to appeal is not required because the appeal takes the form of a rehearing. The Crown Court is not concerned with what happened in the magistrate's court. One corollary of this is that a witness who was not called in the magistrate's court can be called in the Crown Court, and a witness who was called in the magistrate's court need not be called in the Crown Court. This means that both sides may reconsider any tactical decisions regarding which witnesses to call, which were taken prior to the trial in the magistrate's court. Similarly, the hearing by the Crown Court of an appeal against the sentence imposed by magistrate's court takes the same form as the original sentencing hearing in the magistrate's court, with the prosecutor summarizing the facts followed by a plea in mitigation by the defense advocate. When advising the defendant whether or not to appeal to the Crown Court, counsel should warn the defendant that the Crown Court has the power to increase the sentence imposed by the magistrate's court up to the maximum which the magistrate could have imposed. This is so even if it is only the conviction and not the sentence which is the subject of the defendant's appeal. Alternatively, In a case which involves a point of law or jurisdiction, the defendant may appeal instead to the High Court. Now, this can be done in two ways. The first is to ask the magistrates to state a case for the opinion of the High Court, known as appeal by way of case stated. The magistrates duly summarize their findings of fact and their rulings on the law, and the High Court considers whether the magistrates reach the correct conclusion. The second way is to apply by judicial review of the decision of the magistrate's court. This method is particularly appropriate where the magistrates exceeded their powers in some way or there has been procedural unfairness. The prosecution can also appeal to the High Court by way of case stated or seek judicial review on a point of law or jurisdiction and thereby challenge an acquittal by a magistrate's court. And finally, let's consider appeals from the Crown Court. Appeals from the Crown Court against conviction and/or sentence go to the Court of Appeal, Criminal Division. Sometimes the appellant is represented by the same barrister who appeared in the Crown Court. Sometimes a different barrister is chosen. In any event, counsel for the appellant has to examine the notes which were taken during the trial by counsel for the defense to see if any errors occurred during the course of the trial. Particular attention has to be paid to any rulings made by the judge during the course of the trial, for example, rulings on the admissibility of particular evidence, and to the judge's summing up of the case to the jury. As far as the latter is concerned, counsel should consider whether the judge stated the law correctly and whether the judge summarized the case for the prosecution and the case for the defendant accurately and fairly. Similarly, the comments made by the judge when passing sentence should be scrutinized with care to ensure that the correct sentencing principles were applied. If errors were made in the course of the trial and/or in summing up, or when sentence was passed, grounds of appeal have to be drafted. These grounds must identify the errors that were made and must refer to any relevant case law. This is an important document since it forms the basis of a decision by a Court of Appeal judge whether or not to give leave to appeal. Once an application for leave to appeal against conviction has been launched, a transcript of the summing up and any other rulings made by the trial judge will be sent to the barrister who drafted the grounds of the appeal. Counsel then has the chance to perfect the grounds of appeal, that is, to relate those grounds to the transcript. The hearing of the appeal itself takes the form of argument by counsel for the appellant and counsel for the respondent. No evidence is heard except in exceptional cases, for example, where the conviction is said to be unsafe in the light of evidence that has emerged after the trial. Under Part 9 of the Criminal Justice Act 2003, the prosecution also have limited right of appeal to the Court of Appeal against terminating rulings by Crown Court judges made either at a pretrial hearing or at any time during the trial itself. A terminating ruling is one which has the effect of terminating the trial and includes both rulings that are terminating in themselves, such as the upholding of a submission of no case to answer, and also those that are fatal to the prosecution case. The prosecution proposes to treat them as terminating and, in the absence of the right of appeal, would offer no further evidence against the defendant. The prosecution cannot, however, appeal against an acquittal by the jury. And with that being said, that concludes the various stages of a criminal case. This has been Toks Hussain, and I hope you found that very insightful.